What specific mental health records are protected under HIPAA? Have you ever wondered what mental health records are actually protected under the Health Insurance Portability and Accountability Act? This is especially relevant when discussing gun ownership and Second Amendment rights. Let's break it down. First off, most mental health records fall under the category of protected health information. This includes things like diagnoses, treatment plans, prescriptions, and session summaries. Healthcare providers must keep this information secure. However, there are exceptions. If a patient poses a serious threat to themselves or others, providers can disclose this information. This aspect often comes up in discussions about firearm access. Next, we have psychotherapy notes. These are different from general mental health records. They contain a clinician's private thoughts and analysis about therapy sessions. Because of their sensitive nature, these notes cannot be shared without explicit patient consent, except in rare cases like court orders. This distinction is essential in Second Amendment discussions. Psychotherapy notes usually do not affect firearm eligibility, which often relies on broader mental health adjudications. Another important area is records related to substance use disorder. These records are protected by additional confidentiality rules under federal law. They requiring specific consent for disclosure, even when it comes to firearms. However, most background checks focus on court-ordered commitments or involuntary holds, not routine treatment records. Now, let's talk about how these protections play out in the context of the Second Amendment. Many conservatives argue that while HIPAA protects mental health records, there must be a balance with public safety. For instance, HIPAA allows for the reporting of mental health information to prevent harm. This aligns with the belief that responsible reporting can help reduce risks without infringing on rights. Federal law states that individuals adjudicated as mentally defective or involuntarily committed cannot purchase firearms. HIPAA permits providers to report these adjudications to the National Instant Criminal Background Check System, provided state laws allow it. It's also worth noting that some states have stricter rules regarding mental health data in firearm eligibility checks. This reflects an effort to balance privacy rights with community safety. In summary, while HIPAA protects most mental health records, it also allows for necessary disclosures to address imminent threats or comply with legal obligations. This framework supports the idea that existing privacy laws can enable responsible information sharing to prevent firearm access by individuals who may pose a danger.